Asbestos disease and asbestos injury is different than a lot of other litigation in this respect. Let's say you're a nuclear power plant worker and you're exposed to a problematic amount of radiation. You're going to get sick right away or pretty quickly. With asbestos, that is not the case at all. There is something known as a latency period. And the latency period is that period of time, or that difference between when you are exposed to asbestos and you develop the injury. It is a long time. At its shortest, it is a long time. The most common latency period range, if you will, that is discussed in the literature is 10 to 15 years on the short side and as many as 50 years on the long side. Oftentimes, the company that is responsible, or one of the companies responsible for the asbestos exposure that made someone sick, is no longer there. They can be no longer there because of general business reasons. The company just stopped making money, or more commonly, that company has filed for bankruptcy protection. It's our job to assess who's responsible and how do we get at the company who was responsible. If the company has completely vanished, what we will attempt to do is find dormant insurance policies. And those policies do not vanish. They may be hidden, but it can absolutely be a situation where we can find those policies and do our best to tap those policies for our clients. Regarding the companies that have filed for bankruptcy protection, sometimes these companies will go into bankruptcy and cease existence. They're done. And in that situation, what we do is we file a bankruptcy trust claim. The fact that the asbestos company who is partially responsible for your disease is no longer there, that does not mean that we can't pursue compensation from those exposures. We just have to get a little inventive in the way that we do it.